Good afternoon, everyone. Good afternoon, ma'am. We will going to continue the report that we did last Wednesday regarding Module 13, the teachers and the higher authorities. The first few topics of it has been already discussed, right? And it ended on Section 6 of DepEd Order number 49, Series of 2006. So, under the same DepEd Order, I am opted to continue discussing to you Section 7 to 9. But before we formally begin, I would like to ask some favor to all of you to silently read on your respective areas the context of the sections that I will going to discuss in order for us to save some time, because we still have some lengthy discussions to make along the way. So, now let's start. Section 7, Withdrawal of the Complaint. It tries to imply that even if the complaint will be withdrawn, it doesn't mean to imply that the person being complained to will be officially out from the case against them, especially if the complaint have a concrete and strong evidences that will really pinpoint or that will really affirm that he or she is indeed guilty of committing something among what's stated in Section 2 of this DepEd Order, such as those dishonesty, oppression, misconduct, so on and so forth. So that's it for Section 7. Moving on to Section 8, Actions on the Complaint. Well, it have 4 different actions that can be made on the complaint. Let's start with letter A. It states that if the complaint have an obvious falsity in its information or false accusation, the disciplining authority assigned to handle it shall directly dismiss or drop the said complaint. Next, letter B, it just goes the same with letter A because, accordingly, disciplining authority shall also dismiss the complaint if either the complaint does not have a concrete, simple, and concise information, and if the action being complained to does not included among the list of the grounds for disciplining action or among the list of the activities stated in Section 2 under this DepEd Order. Again, such as those dishonesty, oppression, misconduct, so on and so forth. So, moving on to letter C, it states that if the complaint is still needing further information or documents and evidences, the disciplining authority shall let the one who complains to appoint its investigator or investigators to sort those things out by conducting a fact-finding investigation, or also known as preliminary investigation. And that said investigation should be ended within 10 days. So lastly, letter D. It states that any anonymous complaint will not be processed, not unless if the disciplining authority will decide to adopt it in its identity. So, meaning to say that if the disciplining authority will decide to have its identity anonymous as well, that is when the moment that the anonymous complaint will be approved and filed motu proprio. When we say motu proprio, it describes an official act taken without formal request from another party. So, meaning to say that the disciplining authority decides to file and approve the anonymous complaint on his own. So, that's it for Section 8. Now, let's move on to Section 9. Fact-finding investigation or preliminary investigation. Basically, this talks about the whole process or the things to be considered when we say fact-finding investigation or preliminary investigation. So, let's start with letter A. It states that the investigator or investigators appointed to lead the said investigation shall begin the fact-finding investigation by issuing an order to the one who complains to submit within 3 days a counter affidavit or comment under oath and affidavit of its witnesses. So next, letter B, it states that when the counter affidavit or comment under oath has been already submitted, the investigator or investigators may invite both of the parties in a conference where they might ask propound clarificatory questions regarding the case or the complaint, or may interview any of their possible witnesses. So this is when the starting point for hearings to legally and equally settle the said complaint. So next, letter C, it states that during the process for propound clarificatory questions, the investigator or investigators shall maintain or follow unified time frames both for asking and answering of questions, and that time frame should be signed by both of the parties as an agreement and shall be included on the records of the case. Moving on to the next one, letter D states that right after the hearings for propound clarificatory questions, the investigator or investigators shall directly assess or examine the documents submitted by both of the parties, and as well as the documents that are readily available from other government offices that has something to do with the case or the complaint. Next, letter E, it states that the fact-finding investigation or preliminary investigation shall begin not later than 5 days from the receipt of order by disciplining authority who appoints certain individuals as investigator or investigators that which shall lead the said investigation that should be ended within 30 days right after the receipt of order has been issued. Basically, this talks about the span of time for the whole process of the fact-finding investigation or preliminary investigation. It talks about when should be started and when should be ended. Next, letter F, which talks about the investigation report. So it states that right after the fact-finding investigation or preliminary investigation has been ended, the investigator or investigators are obligated to directly submit to the disciplining authority the complete records of the case, and as well as the investigation report, which contains with their own findings and recommendations of the said case. Lastly, letter G, it states that if a prima facie case is established during the investigation, a formal charge shall be issued by the disciplining authority. So when we say prima facie case, it pertains to the circumstances where other party was favored to provide evidences to contradict the verdicts against them without being rebutted by the opposing party. So when this kind of activity is established during the investigation, the disciplining authority shall give formal charges to the respondent or respondents. However, it should be investigated thoroughly first and shall have a reasonable ground to affirm that the respondent is indeed guilty of the given charges against him or her. So that's it for section 7 to 9. As for the section 10 and onwards, Mr. Ukab will take over to discuss it to you.
Good afternoon everyone, my name is Granger Ukab and I'm going to discuss Section 10 of formal charge, Section 11 submission of additional evidence, and lastly the Section 12 prohibited pleadings. Okay, so Section 10, a formal charge shall contain a specification of charges, a brief statement, material or relevant facts about accompanied certified true copies of documentary evidence, if any, sworn statement covering the testimony of witness, if any, a directive answer under the oath, the charges in writing in not less than 72 hours or from the receipt thereof, and advice for the respondent to indicate in his answer whether or not the elicts a formal investigation of the charge, and notice that he is entitled to be assisted by a counsel of his choice. Now, this statement in Section 10 clearly says that a respondent must submit specific material about the evidence and fact that based on certified true copies of documentary together with the witness or testimony documentary. Now let's proceed to Section 11, submission of additional evidence. This statement, if the respondent had already submitted his comment under oath or counter affidavit during the fact-finding investigation or preliminary investigation, he shall be given the opportunity to submit additional evidences. This statement clearly says that a respondent must be able to he or she have the chance to submit additional evidences for the investigation. Okay, so Section 12, the prohibited pleadings. The disciplining authority shall not entertain dilatory requests for clarification, bills of particulars or motion to suspend proceedings or order to injunctive rate. If any of these pleadings are interposed by respondent, the name of shall be considered as an answer and shall be evaluated as such. Section 12 clearly says that after the investigation, the evaluation, the respondent will not entertain, he or she submit additional evidences for the ongoing investigation, because it is prohibited by the pleadings and the authority will not accept any dilatory request. So I hope you learned something about my discussion, and for the continuation, let's proceed to Ma'am Aiza Tabana. Thank you.
Section 13. Answer. The answer, which shall be in writing and under oath, shall be specific and shall contain material facts and applicable laws, if any, including documentary evidence, sworn statements, covering testimonies of witnesses, if there be any, in support of his defenses. It shall include a statement indicating whether or not he elects a formal investigation. The defendant must write an oath that states only facts, evidences that support his innocence. If there will be any witness, the witness shall provide also a statement that states factual information. If the witness has a documentary evidences like pictures, videos, etc., they must also submit it, and also the defendant must undergo a formal investigation. Section 14. Failure to file an answer. If the respondent fails or refuses to file his answer to the formal charge within 5 days from receipt thereof, he shall be considered to have waived his right thereto, and the formal investigation may commence. If a respondent failed to file his answer within 5 days, he had waived his right, but the formal investigation may still commence.
Good afternoon, everyone. Today I will discuss the Section 15 and Section 16. Section 16. Preventive Suspension. Upon motion of the complainant or motu proprio, the proper disciplining authority may issue an order of preventive suspension upon issuance of the formal charge immediately thereafter to any subordinate officer or employee under his authority pending an investigation if the charge involved dishonesty, oppression, grave misconduct, neglect in the performance of duty, or if there are reasons to believe that the respondent is guilty of charges which would warrant his removal from the service. When the employment possesses serious and imminent threat on the life or property of the employees or any of his representatives, the employee may be placed on preventive suspension. For example, stealing or pagnanakaw. It is an act taking a personal property of another without the consent of the owner. In that case, the disciplining authority will issue an order of preventive suspension. Preventive suspension can be issued if the formal charges is already gave to any subordinate officer or employee under his authority while waiting for the investigation, if the charges involve dishonest, oppression or pagpanglupig, grave misconduct or wrongdoings, neglect in the performance of duty, or kapabayaan sa pagganap ng tungkulin, or if there are reasons to believe that respondent is guilty of charges which would warrant his removal from the service. Section 16. Reason for preventive suspension.
An order of preventive suspension may also be issued by the disciplining authority to temporarily remove the respondent from the scene of his misfeasance or malfeasance and to preclude the possibility of exerting undue influence or pressure on the witnesses against him or tampering of the documentary evidence on file with his office. Example for this, if the case is stealing, then that person or the respondent didn't remove from the scene, then he might steal more things and can cause harm to anyone. That's why the disciplining authority will temporarily remove him or will issue the preventive suspension to prevent from causing harm and injury or trouble to the company as well as to his fellow employees. And for the next section, it will be discussed by Micaela.
Good evening, everyone. I am Ms. Rabanes, and I am the last reporter for our group, and I will be discussing the last 4 sections of our discussion. Let's start with section 17. Section 17's title is Substitute for Preventive Suspension. So our keyword for this section is substitute. So in this section class, the respondent or the person with existing suspension or under suspension will be reassigned to other unit of the agency. So example, teacher A is a grade 3 teacher and he is under suspension. So in order for him to continue his duties and responsibilities, he will be reassigned to other unit. He can be reassigned to other grade level, other administration, other position, or other classroom. So in short, even though you are under suspension, you will be reassigned just for you to continue your duties and your responsibilities as a teacher. Next is section 18. Section 18's title is Duration of Preventive Suspension, and our keyword is duration. So the duration of the suspension is only 90 days. So after 90 days, if the administrative or the disciplining authority hasn't decided yet on the suspension, the respondent will be back on his position. But if the suspension is delayed due to the respondent's fault, negligence, and the respondent's petition, it will not be included in the 90 days. So let's go back to teacher A. He was reassigned to other unit, right? Let's make it as teacher A was reassigned to grade 4 level. So after 90 days of suspension, if the administrative or the disciplining authority hasn't decided yet on the suspension or wala pa sila ka-decide kung unsa ang hukom, teacher A will be reinstated or can go back to teaching grade 3 level after the 90 days of duration. So what if class teacher A has a wife, which is si teacher B, and si teacher B is also under suspension, but she is also pregnant and will be on maternity leave. So pila man ang duration sa suspension ni teacher B? So the duration of the suspension of teacher B is also 90 days. But if this is the case, class, the duration will be interrupted and it will only resume at the end of the maternity leave. So aya na daw mag-start ang duration sa suspension ni teacher B if mahuman na pud ang iyaang maternity leave. Okay, let's move on to section 19. Section 19's title is Remedies from the Order of Preventive Suspension. So, keyword for this section is remedies. So, section 19 talks about filing a motion for reconsideration by way of appealing to the disciplinary authority or the Civil Service Commission. So, you can only file a motion within 15 days after the order of the suspension. Let's example again teacher A. So, example, he received an order of suspension right now, karon na adlaw. So, he will have 15 days to have a file for reconsideration, such as lessening the duration of the suspension. Then, it will depend on the disciplining authority if they will accept it. So, kung mulapas na ka og 15 days sa pag-file og motion for reconsideration, dili na siya madawat kay nilapas naman siya sa 15 days na duration para maka-file ka og reconsideration. let's start with section 20, the formal investigation. So the title itself is our keyword. So class, mahitabo ba ang formal investigation if mag-request si respondent? Okay. So, even though the respondent didn't request for a formal investigation, class, mahitabo gyud si formal investigation because such investigation is compulsory and needed because it will be a big help in deciding judiciously. So, formal investigation will be conducted to go deeper on understanding the complaints of the complainants and the response of the respondents. So, mag-include bud sa formal investigation si interviewing witnesses, listening to both parties, and checking their documents. So, pinaka-importante yun si formal investigation because it will help the Civil Service Commission to decide judiciously or the disciplining authority.